All right. It is 5 o'clock. We are going to go ahead and get started here. Welcome to the Land Use and Zoning Committee. It's March 3rd at 5 o'clock. We will wait for a few other committee members. We can go ahead and get started because we do have quorum. We're going to start with introductions on the left.
Thank you, Mike Gay, District 2, just visiting.
All right. Joe Carlucci, District 5.
Raul Reyes, District 11.
Terrence Freeman at large, Group 1.
Randy White, District 12.
Dylan Rangel with the Office of General Counsel.
Susan Kelly, Planning Department.
Aaron Abney, Planning Department.
Casey Cox, Planning Department.
All right. And we also have 2 pages tonight. Y'all can go ahead and stand up. We have Harper Bell Kimbrough and Alon McLeod. Welcome them. They are here to assist us tonight, so thank you for being here. All right, Councilmember Johnson, thank you. You don't need to check in. We'll just check you in. It's all good. All right, so we'll go ahead on the first agenda item for tonight. Actually, Mr. Gay, did you have a request in to get something moved up? I think we had an email from your office. Is that correct?
Yes, sir, Mr. Chair. It was, it's actually a...
Number 20?
Yes, please, if that's possible.
Okay, yeah, we told your office we would accommodate that, so we certainly will. All right, committee members, that means we're going to start on page 9 of 13 with item 20. Everybody ready? We're starting off fast pace. So item number 20, 2026-107. Council members, please declare any ex parte communication you have at this time. Here we go. And welcome Councilmember Gaffney. Just to bring him up to speed, then we'll go to ex parte. We are starting on item number 20, the appeal to accommodate Councilmember Gay and the other applicants. So with that, we're going to declare ex parte. Councilmember Johnson, you're recognized.
Thank you, Mr. Chair.
Yeah, mic problems today.
Everybody turns their mic off. Okay, for some reason, I leave mine on anyway. Thank you, Mr. Chair. I rise to declare ex parte for this legislation. I've had 17 emails, all in opposition to the appeal. I've also had a phone call on yesterday from Mr. Hertzberg asking if I had any information. And then I called over to the Planning Commission because I had some questions and pulled their transcript. All of that is being filed with Legislative Services. Thank you.
All right. Councilmember White, you're recognized.
Yes, sir. I'll declare ex parte. I have filed all my emails has been filed, and I did have a meeting with Mr. Hirschberg. I had some questions from the original PUD 20 years ago and what they was really adding to that, and all that will be filed. Thank you.
Councilmember Arias.
Yes, Mr. Chair, I'd like to declare ex parte on 3-3. Today, I met with Mr. Herzberg in my office to discuss the appeal, and I've also received numerous emails in opposition as well. Thank you.
All right. Councilmember Gaffney, you're recognized.
Thank you. Through the chair, I also like to declare ex parte. I held a community meeting. I'm not sure of the date. I'll make sure it get filed. I also received emails from constituents. I also spoke with Mr. Herzberg and other members of the constituents. I also rode out to the site and met with Mr. Jason Wright. I'll make sure that get filed with Legislative Services. Thank you.
All right. Councilmember Freeman, you're recognized.
Thank you, Mr. Chair. I would like to declare ex parte as well for all of the same reasons my colleagues said. I've met with the applicant and I've received emails. Thank you so much.
All right, and I have ex parte to declare. I met with Mr. Mike Herzberg yesterday in our city council offices, and we've also received the same number of emails in opposition, and we will get this paperwork filed with Legislative Services. With that, we're going to open the public hearing and get a staff report, or do we not have a staff report since it's Mr. Reingold?
It's a little bit different. So what I'm going to do is I'm just going to tee it up with just how we got here, and then we're going to hear from Mr. Herzberg, then we're going to hear from Aaron Abney, and then a public comment, and then a final rebuttal, and we'll go from there.
Okay, great. That'd be amazing.
So first off, this really started, there was an original PUD approved many years ago, and what happened was Mr. Herzberg, representing the property owner, had filed for a minor modification
to that PUD. That was heard on January 8th, 2026 by the Planning Commission. At that meeting, the Planning Commission took information and comments from the public and voted to deny the minor mod request. With that, Mr. Herzberg, on behalf of the property owner, had filed an appeal of that denial of the minor mod to the City Council and to the LUZ Committee. And with that, that's how we have the appeal and how it got there. So with that, I am going to turn it back over to the chair, and I am assuming we will hear from Mr. Herzberg.
Okay. And do we go to Mr. Herzberg and then Ms. Abney, and then we go to public comment or public hearing cards?
Yes, I think that would be appropriate.
Okay. Mr. Herzberg, you are first, and you're recognized for 5 minutes. Ms. Abney, you have 5 minutes as well. And then we will go to the rest of our speaker cards. Okay.
Mr. Chairman, members of the committee, thank you. Mike Herzberg for the applicant. The subject property was actually zoned almost 20 years ago now, in 2007. And this PUD spelled out various uses, specifically one of those including personal property storage establishments, self-storage, as a permitted use anywhere within the PUD. The original PUD was made up of 5 parcels, and it encompassed approximately 12 acres. The PUD also noted that the site plan was conceptual, and you can see the site plan that was actually approved. I've superimposed some things on top of it, but that site plan that's on the first page of the document that you're receiving is actually the site plan that was approved as part of the PUD. Keeping in mind it was deemed conceptual. One could look at that and determine that I'm not really sure what that was. It might be a retail center, it might be warehouses, it might be something else. It's somewhat unclear. In any event, the request for minor modification that was sought was not an entitlement. This was not a request to allow a use that otherwise wasn't allowed. Rather, it was changing the site plan. The use is allowed by right, as staff will tell you again. Similar uses that were allowed by right in this PUD would be automotive repair or liquor stores, which could be built here tomorrow. So in looking at that, you'll see 2 different colors on that. The first color, the yellow, is the first parcel that the property owner sought and obtained. That was about 4.3 acres. He put that under contract, did his due diligence, and immediately was granted a verification of substantial compliance, which is attached at the back of your handout. That verification says that as of today, the planning department has approved that he has the right to commence building 522 self-storage units on the 4.3 acres. As he did that and got his approval and got ready to go to engineering, the landowner in the green, who also knew the landowner in yellow, said, I would like to sell my acreage as well. Would you be interested in purchasing the additional 1.98 acres? He said, yes, I can expand the project. Goes forward, puts that under contract, turns in a verification of substantial compliance to add some additional units to that, which you'll see further back in the handout that I've got at the last page, the area in green again. And the planning department said, you know what, we probably better get a minor modification for this. We'd like to evaluate the access points, make sure that the PUD is still consistent. In going to the Planning Commission simply misapplied the law. The requirement here was not whether or not the self-storage could be here, and really whether or not any additional trips were being created. The answer to that is no. Vastly reduced number of trips for self-storage than for what would be there with retail. In retail, you might have between 8,000 and 11,000 trips if you were to build out this PUD as a retail facility. The self-storage that's being proposed on about 6 of the 12 acres would generate about 47 daily trips. That's a huge margin. And one of the things that was most clear with those in opposition was traffic in the area. I'm here to tell you, the people that live in this area, I completely understand their plight. I understand their problem, and I do think there's an issue at the intersection. However, this PUD was approved almost 20 years ago. The neighborhood to our east that's complaining about this use was only approved in 2020. So the residences came to the area for an entitled piece of property and contest the use that's being designed or being intended there. To me, I think that's the problem. If you look at the Planning and Development Department's report, they recommended approval of this minor modification. They found favorably on all criteria, and the criteria are included in my report to you tonight. I think if you evaluate those criteria and you consider what was done, what's being sought here is appropriate. And while it be unfortunate, it might not be the use they'd like to have here. Arguably, it might be better than some of the uses that could otherwise be put here. And I understand they'd like to have a nice shopping center or something else, but the property owner has rights just as these folks have rights to build what is allowed under their zoning and applicable for that property. With that, sir, I'll stand by.
Okay, next we will have Ms. Abney.
Thank you, Aaron Abney, Chief of Current Planning. So this is the appeal for minor modification MM 2516, which is requesting to modify a PUD that was approved in 2007. That's ordinance 2007-0382, updating the site plan to reflect the proposed development of a personal property storage facility with a proposed maximum square footage of approximately 85,000 square feet, covering 2 parcels within the PUD. Between the 2 parcels, this modification is for approximately 6 acres of the 12.22 acres that were approved within the overall PUD. The PUD was approved to allow for a wide variety of commercial uses and retail uses, including personal property storage facility, with an overall maximum development of 105 square feet. That would include both the commercial and retail development space. The original conceptual site plan depicted commercial uses near the center of the entire PUD on one of the parcels, and then it also included multiple out parcels with driveway connections along both Yellow Bluff and Sterrett Road, and then also included internal cross-access connections. The updated site plan for the proposed development removes the northern driveway access point along Yellow Bluff and also removes cross-access between the remaining out parcels. It combines 2 of the parcels into one for a combined development of 1 personal property storage facility. Staff reviewed the request and found that it met the criteria in order to forward a recommendation of approval for the minor modification. There were no changes to any of the approved land permitted uses, which does include the personal property storage facility, and there's not a request to increase the floor area. The PUD allows for, again, a maximum of 105,000 square feet, and the proposed facility will be closer to approximately 85,000 square feet. So there's still square footage remaining when the other out parcels eventually do get developed for the other uses that are allowed within the PUD. There's no significant alteration to the general distribution of traffic within the proposed changes due to those driveway connections. The proposed site plan was reviewed by both the traffic reviewer and development services and the transportation division, which had no concerns on the driveway layouts. The proposed changes are a significant decrease in the traffic generation, as with the proposed storage facility square footage and unit count. This business would generate approximately 113 daily trips. If we ran the allowed square footage of 105 square feet for just general commercial or retail uses, it could produce around 6,800 daily trips, which is a significant increase compared to the proposed development of just the personal property storage facility. This portion of Yellow Bluff Road is currently operating at 29% capacity, and Sterrett Road is operating at 37% capacity. There's no changes to any of the conditions that were enacted by City Council. There's no changes to any of the perimeter buffering, fencing, or landscaping, so therefore we found external compatibility was maintained. Condition 2 of the original PUD requires that a minimum 10-foot wide buffer between uncomplimentary uses adjacent to residentially zoned properties or uses. So this will be required along the northern property boundary. However, we do want to note that while the property to the north is zoned RR acre, it is owned by JEA and is operating as a power line facility. Condition 4 of the original PUD also will be complied with, as a 15-foot wide natural landscape buffer will be provided along Yellow Bluff right-of-way, and it's labeled on the site plan as such. So that condition will also be maintained. There's no changes to any of the perimeter lot sizes or building heights, so therefore external compatibility is maintained. The PUD was always contemplated for commercial uses. There's no residential uses allowed, so there's no changes to any lot sizes that could be along the perimeter. And then the height will meet all the requirements of the PUD today. So because of these reasons and those listed in the staff report, the planning department forwarded a recommendation of approval for the minor modification. As Dylan explained, this application was heard by Planning Commission on January 8th, where there were several speakers in opposition. They cited concerns related to increase in traffic, especially near the intersection of Yellow Bluff and Starrett, where there has been several car accidents that have occurred. Ooh. Okay, I'm almost finished. Where, car accidents have occurred. Concerns also included that the community felt the PUD approval from 2007 was not reflective of the development within the area today, which is mostly residential, and did not find that the personal storage was appropriate and compatible with the existing development that's out there today. Several members of the Planning Commission felt the use of personal property storage was on the least intense uses allowed within the PUD, and understands the entitlements of the uses that have been allowed on that property since 2007. So they felt that the proposed use and the site plan were consistent and compatible. One of the commissioners, Commissioner Carter, voiced concerns that the area is not the same than it was in 2007 when the original PUD was approved, and had concerns on the reduction in driveway connections for ingress and egress, and traffic could be significantly altered with just the one entrance along Starrett. But ultimately, the commission voted to deny the minor modification of a vote 4-3. And I'm here for any additional questions that you have. Thank you.
Okay. All right. Just to recap before we go to all the speaker cards, I just want to make sure that all the committee members understand, and Mr. Rangold, correct me, the minor modification, that just goes to Planning Commission. And it got denied at Planning Commission. Planning Department issued a recommendation of approval, and when anyone wants to appeal something that just goes to Planning Commission, they appeal it to LUZ and full council. That's where we're at. Okay, cool. Just making sure everyone's kind of following along. So with that, we will go to our speaker cards. We have, and if y'all want, when I call your name, you can come down to the front row. We have Blake Adams, Robert McFeely, Ruth Nelson Peoples, Rita Sweat, and Susan Shinego. Come on down, take your seats on the front row, and everyone will get 3 minutes. First up was Blake Adams.
And before Mr. Adams starts, I'll just remind the committee, this is a de novo review, so all the new information that comes in today is very valid and applicable to the appeal.
And is there any scope that this has to stay within?
It's just the criteria for a minor mod. So you have the same criteria that the Planning Commission considered. You're just hearing it on an appeal.
Okay, great. Mr. Adams?
Good morning, good afternoon, Commission. My name is Blake Adams. I work for the Florida Department of Law Enforcement as your regional legal advisor here. So we handle everything from Nassau down to Levy. I was a state attorney for 10 years prior to that. I'm not going to put my address on the record because it is exempt. However, I will let you know I do live in this affected area. As such, you've kind of already heard some of the main concerns last time at the committee. I did speak at that as well. Some of the main concerns were that this was zoned 20 years ago, and as you all know, this community has changed. Many of you, I'm sure, have been on committees that have approved all of the residential neighborhoods around there. As such, we don't need more storage units. I remember at the last hearing, several people brought up maps to show that I believe within just a few feet from these communities, we have 8 of them already. Like we're inundated with storage units in this general area, from the freeway down to Main Street. We have so many. Another big concern, like they said, was the small one-lane roads with increasing congestion as we get large moving trucks coming up and down. I don't know if any of you have ever driven on Starrett around 5 o'clock at night, but if you do, you will sit at the light at Starrett and Yellow Bluff for anywhere from 25 to 30 minutes trying to make a left-hand turn. It is terrible. And if that is where the entrance to this is going to be, we're going to have to wait for trucks to get through a gate to get in there for security reasons, where it's only going to cause worse traffic, and you're going to have people fleeing or going around these trucks, and it's going to cause even more car accidents at this area. Another thing that was brought up was low-income property that attracts nuisances. As many of you know, unfortunately, the reality of storage units are that they do attract crime. There are things that are held in them that shouldn't be held in them, and there's not a lot that is done. Law enforcement, JSO, FDLE, we do our best to try and prevent that as much as we can, but we can only do so much. The fact is it's going to attract nuisances. Another thing that was brought up that I think is incredibly important is the light pollution that will be created by this. If this is created, this is going to be a large-scale, outdoor, low-income property that is going to have light 24/7 to allow entry for people to get into these. That is going to cause so much light pollution for the residents that live directly across it in multiple directions. Another concern with that is that I know people are going to say, well, you already have a gas station right there on the corner and you have another thing. They actually turn the lights off after 10 o'clock and dim the gas station lights to allow for this. The Circle or whatever, I think it's a Dollar General. They actually they turn their lights off and the gas station reduces its lights to help with the light pollution. I'm running out of time here, so I will just say that I don't think the committee got it wrong. They were correct. This isn't a small, minor modification. This is a large modification. If I could have just a few more seconds.
No, sir, I'm sorry. We can't allow that, but we appreciate your comments. Next, we have Mr. McFeely.
Good evening, Council. I'm here to voice my opposition to Appeal 2026-107. I would like to highlight several direct conflicts with the future land use element as cited in the printout. This case is before you because the Planning Commission denied the applicant's request to modify the existing PUD to allow a personal property storage facility. The applicant is now asking you to overturn that decision. The issue today is not whether the committee might have reached a different conclusion. The issue is whether the Planning Commission denial was supported by competent, substantial evidence and consistent with the comprehensive plan and adopted PUD framework, which it was. At first, it was presented as a minor modification. However, the original PUD contemplated active commercial development with the long-term vision of this corridor. Replacing that development pattern with a large self-storage facility is not a technical refinement. It's a fundamental change in land use function and long-term outcome. Minor modifications are intended for layout adjustments and dimensional changes, not for substituting an entirely different commercial model that permanently alters the economic character of the site. The Planning Commission correctly recognized that distinction. Second, the Commission properly considered consistency with the comprehensive plan and the intent of the CGC. The FLU emphasizes efficient use of commercial land, reinforcement of active corridors, and protection of long-term development opportunity. A self-storage facility does not meaningfully advance those objectives. It generates minimal employment, limited daily activity, and commits commercial designated land to static use. The applicant argues that this use is less attentive than retail, but reduced traffic is not the standard. Planning decisions are not based solely on trip counts. The comprehensive plan requires functional compatibility and advancement of long-term land use goals, not merely compliance. Third, granting this appeal would weaken the integrity of the PUD process. It would signal that substantial shifts in development patterns can be achieved through a minor modification rather than through the higher level of review which is required for major changes. The Planning Commission, Third, this appeal weakens the the Planning Commission reviewed the evidence, appealed the correct standards, and determined this proposal was inconsistent with the intent development pattern. There was no showing of legal error, arbitrary action, or lack of evidentiary support. In closing, one has to ask why this applicant is so persistent in moving forward with this proposal when both the community and the Planning Commission have clearly indicated that it does not align with the adopted vision for this corridor. An appeal should not be used to bypass this process. For this reason, I respectfully urge you to deny the appeal and uphold the Planning Commission's decision. Thank you.
All right, next we have Ruth Nelson Peoples.
Good evening. My name is Ruth Nelson Peoples. My address is on file. When this storage unit proposal was approved on August 5th, 2026 by City Planner Andy Hetzel, from retail space to storage units, it was for 522 units. Representative Hertzberg tried to tell us it was 550 units, but that is not what the documents show. Now we are being told the applicant wants to expand the footprint, add additional land, and increase the number to 650 units, almost 130 units more than was approved on August 5th. This is not a minor modification. This is a significant intensification of use. Under Muni Code Section 656.340, a PUD is intended to produce superior site design, compatibility with surrounding properties, thoughtful, unified planning. It is supposed to provide greater protection and predictability for a community, not incremental expansion after the fact. If there were already concerns about compatibility, security, oversight, and land use impacts at 522 units, those concerns intensify with 650 units. We are talking about an unmanned facility with no on-site supervision. Security is provided only by cameras. There are no guaranteed business hours and no on-site staff. No on-site staff. These type units are frequently used by landscaping companies, painting contractors, automotive repair operators, and other commercial users who store chemicals, equipment, machinery, and potentially hazardous materials. With no on-site management actively monitoring what is being installed, increasing the number of units increases the risk of that scale. More units means more activity, more traffic, more opportunity for improper storage, more potential for unauthorized occupancy. As I mentioned before, these types of facilities have been known to become de facto workspaces and even living spaces for the homeless. Expanding from 522 to 650 units only magnifies those enforcement and safety concerns. A PUD is supposed to raise the standard of development. Expanding the size and intensity of an already questionable use moves us further from that purpose, not closer to it. Does increasing this project by 130 units improve compatibility? Does it strengthen the area? The answer is a resounding no. PUDs exist to ensure the flexibility, and zoning produces a better outcome for the community. For these reasons, I respectfully ask you to deny this appeal.
Okay, thank you. Next, we have Rita Sweat, and then, oh, you don't want to speak? Okay. We have Susan Shinego, and then if the following speakers will come down to the front row, Samantha Series, Catherine Del Rey, Risa Grant, and Laura Fulford. And up now, Ms. Shinego?
Yes.
Okay.
Susan Shinego, address on file. We were told at a community meeting that they were not sure, this was with Mr. Herzberg and the builder, that they were not sure and 100% positive whether these facilities would be 24-hour access. If they control the plan, why can't they tell us definitely that it's going to be 24-hour access or not 24-hour access? I believe this plan should be put on hold until that question is answered with a 100% guarantee. 24-hour access in a residential area is not going to be a good thing. LETS needs all pertinent information in order to make an informed decision. Middle of the night access to garage, bay-type storage units right next to residential areas is likely going to be noisy, potentially dangerous, and not conducive to a neighborhood environment. They also said there was going to be vinyl fencing, which is what we were told would be protecting this storage facility. It's very simple to break through these. Just down the road, there's vinyl fencing. I can give you these pictures that were broken through with homeless wanting to get to the other side. The damage to this fencing was not caused by wind or weather. It was caused by homeless who wanted easy access. We've also been told that no human will ever lay eyes on the renters of these units. Obtaining a unit will be done online. Access to the facility will be through the renter's phone. There will be no office, no staff, ever. Security will be through artificial intelligence. What is the reaction time when AI detects something illegal is happening? What happens when the AI security system goes down? How long will you have to go without any type of security monitoring when this happens? How does AI stop a person from storing drugs or chemicals inside their storage units if those things are being brought in unmarked boxes? How does AI stop multiple people from coming into the facility in the same car if one of those people owns the unit and is making a drug deal inside one of the units? How does AI stop a person from living out of their storage unit? In summary, having 24-hour access, flimsy vinyl fencing, and no human that ever lays eyes on the renters from the day they sign the lease to every time they come and go poses a lot of risk to our community and for no reason other than the monetary gain to the developer and owner. If this type of facility is the builder's and developer's preference, build it in a more suitable industrial area. This section of Jacksonville has been changed significantly since being changed by LUTs from rural residential to PUD back in 2007. It's now a residential area, and it's not suitable for bay garage-style storage facilities. This builder and developer can do better for our community.
Okay, thank you. Next, we have Samantha Series.
Samantha Series, address on file. I do not live near here, but I was talking to some of the residents, and I told them I would help them out and, not represent them or anything like that, just another speaker for them to have someone oppose this appeal. I think the Planning Commission did the correct job. They reviewed all the evidence that were provided and came to a decision. I think that it's important to uphold those decisions at these times, and especially with all these concerns that the community does have for this area. It doesn't seem like a minor change. It does seem like a lot of units being added. I think maybe if the community was given a little more information about what the site was actually going to be, if it's going to be a 24-hour site, or if they plan on doing what like the gas station does, where they lower the lights, which is interesting. So I think it's important to listen to the community members. I think they understand this area pretty well, and I hope that you guys are paying attention. I was also informed there's a possible conflict of interest with one of our council members having a staff member as a son of the attorney that represents this applicant. So I think that it's important we also make sure those are considered. Thank you.
Okay, next we have Catherine Del Rey.
Good afternoon. I'm Catherine Del Rey. My address is on file. I oppose any additional storage units added to this PUD. Many things have changed in Jacksonville and in our way of living. I'm asking if the city does at the very least a new and relevant traffic study at the intersection of Yellow Bluff and Starrett, as this PUD will directly impact this intersection, which crash stats have doubled in the 3-year period of 2020 to 2023. While the applicant will make many statements and promises of the state of the art for this storage unit, when one really gets down to it and examines them, they really only benefit the developer, not the local citizens. I live very close to this intersection. It is my only way to go shopping and get to a major highway. I've passed out a map to you that shows you 6 storage units less than 5 miles from this proposed location, including one that is only 3.2 miles away. I oppose any additional storage units added to this PUD. City Council is elected to represent the citizens of Jacksonville, not rule over them, and to preserve the zoning laws which are in place to preserve the property values, lifestyle, and the ecosystem of the city. New rules should be drawn up with a PUD time limit, as many other counties in Florida have an 8-year maximum. In today's world, 20 years is a very, very long time in this fast-moving world for this original PUD to stand. I pray you hear us. City Council should be watching over the interests of the citizens of Jacksonville. City Council needs to ask itself, where is the justification for each of these PUDs? Each and every one of you should do due diligence before granting these zoning changes, which seem to benefit the developers. We are not spectators. We are stakeholders in the future of Jacksonville. So I ask, are you a politician or the voice of the people who elected you? Thank you.
All right. Next we have Risa Grant.
Good evening, committee. I'm Risa Grant. My address of 33 years is on file. Welcome to Storage Wars, Ocean Way Edition. My neighbors and I have been drafted into a battle we never thought imaginable. Why are we caught so off guard? Maybe because the developer is planting a self-storage facility smack dab in the middle of a residential neighborhood, our beautiful, formerly rural residential neighborhood. Although permitted by the PUD, and the applicant admittedly has the legal right to build this type of commercial or industrial structure here, that doesn't make it the best decision for our community. It doesn't add any jobs, doesn't add an aesthetic value, and threatens to bring additional crime to the area. If the applicant didn't think crime was a concern, he wouldn't boast so much about how awesome a security system he'll have in place. I think he's trying to circumvent an anticipated problem. Also, ladies and gentlemen, Jacksonville has the distinction now of being the second fastest rising self-storage market in the country. Is that a title we really want? Everywhere you look, there's a self-storage facility, and new ones are popping up everywhere. That, in and of itself, is a sad commentary on our society's inability to discard things, or that we have a surplus or acquisition problem. To a large degree, these units are being rented for more space to store our stuff. Heck, even the developer needed more space and applied for a modification to expand the scope of his project. Kind of ironic, don't you think? While it's indisputable that these units are being built at a frenzied pace, the vast majority of them are built in commercial and industrial areas or near interstate highways. They don't get crammed in the middle of residential neighborhoods. Lastly, consider this. If you read the policies at every one of these facilities, you'll find a reference to the Florida law that expressly prohibits using a self-storage unit for living or residential occupancy. Under the Florida Self-Storage Facility Act, Chapter 83, Part 3 of the Florida statutes, a self-storage facility and self-contained storage unit are defined strictly for the storage of personal property, and the statute states that no individual storage space may be used for residential purposes. Well, if the applicant expects his customers to respect his rule that says they can't set up camp in his space, then show us the same courtesy and don't set up camp in ours. To those of you who will vote tonight and vote on future self-storage facilities, I ask that you save our great city from becoming known as Storageville. I urge you to vote no to this not-so-minor modification. This particular ordinance and resolution has not had a normal track getting here. It has seen its share of questionable procedural derailments. It's not meant to be, and it's being forced through and thrust upon us. Err on the side of caution and vote no. I thank you all for your time.
All right, next we have Laura Fulford.
Laura Fulford, address on file. I live near the area, so I drive through that intersection often. I come here in opposition of the minor modification, but also to oppose the site plan approved on August 5th, 2025, that lists the proposed development of 522 storage units in a residential area. If you notice on the site plan, it does not include two adjacent properties on Sterrett included in the original PUD, 2561 Sterrett Road and 2677 Sterrett Road. These properties are being used for residential purposes, and by not being included will not create a cohesive, well-thought-out development as intended by the original approved site plan for the PUD dated in January of 2007. I also don't believe that it would be appropriate to place storage units right in the middle of two properties being used for residential purposes. Storage units will not benefit the surrounding community and will mainly bring in business from outside the immediate local area where there are apartments and townhomes. About 300 to 400 single-family homes are about to be built north and south of Sterrett Road, and what we really need to benefit the community is commercial retail offices that will create more jobs. There are also plans to widen Yellow Bluff Road and improve the intersection at Sterrett and Yellow Bluff, so traffic is less of a concern because of that. Storage units are allowed under the original PUD Ordinance 2007-382. However, intentions of the original rezoning of the 12.22 acres was for commercial retail and office uses. The east side of Yellow Bluff is a PUD with the neighborhood commercial category. I believe the 2007-382 PUD should stay within that category to meet the needs of the surrounding residential community. Also in the CGC category, Storage units are not suitable for rural areas because it encourages urban sprawl. And in a suburban area, it's preferred in locations supplied with full urban services and areas with existing mix of non-residential uses. I'd also would like to make sure that the storage units, if they are approved, are built with a masonry wall, increase the 10-foot buffer to a 20-foot so that natural trees could hide the storage units. And the masonry wall would actually provide more security for the storage units and would not be easily broken by wind or anything. And also limit the hours of operation. But I do urge you not to approve this PUD. Minor modification. Thank you.
All right. Next, the following speakers have checked that they do not wish to speak. If that is incorrect, please raise your hand and come on down. Jason Reif, you do wish to speak? Okay, come on down. Sorry, there's kind of a slight dot on the box there.
Maybe I did check the wrong box.
All
Jason
good.
Reif, sorry?
All good. Go ahead, sir.
Jason Reif, address on file. I just want to start out by saying I adamantly oppose the addition of this, and here are some reasons why. The original PUD site plan was listed as a commercial retail, clearly depicted by anchor store and outlying stores. Obviously, that's been trumped by the August one that went through. Traffic is not the critical issue, as most would try to portray. Self-storage produces zero economic growth for the area, no jobs, no city or property incentives to improve the area. And this is based on the 2045 plan, where it clearly says that these types of developments could be blight for years to come, decades to come. North Jacksonville Vision Plan clearly outlines that the storage units are suited for heavy commercial and industrial areas close to freeway interchanges, not suburban communities. The signage for this was very poor as far as when it was put up. It wasn't put up until after it was addressed by the community, which was about 12 days after their required time. They're asking for a third more property to be added to this and a 25% increase in the number of units on that 2 acres. The Planning Commission denied their approval, and one of their references was this, Florida Statute 656 used for them to justify, or one of the reasons why they justified their disapproval. Some of the things we were promised, a 50-foot driveway, don't see that in the site plan off of Sterrett. We're told that there's 2 signs in the site or the PUD, which we asked since they got rid of one of the driveways to remove it from the PUD, and they just basically said, well, we promise not to do it. So they could technically add another sign even though there's not an entrance there. Criminal activity and emergency response is bad enough as it is in the area. Police, I think Dunn Avenue is the closest police precinct to us. So anything that happens out here is hard to get any police to. Fire, there's one up the road. But as far as like hazmat fires, things like that, we don't have the facilities to take care of that kind of thing. They talked about housing and things like that and why we need storage units. Basically, it's bad planning on the city for allowing these small houses to be put into neighborhoods, basically forcing us to have a problem of a storage issue for people, which in turn makes us suffer by forcing us to have these storage units in place in neighborhoods where they don't belong in the first place. And I would just also ask that on the record that the council member recuse himself for this vote due to potential conflicts. That's all I got.
All right. So the following speakers checked that they do not wish to speak but are in opposition. Linda Mack, Thomas Mack, Nancy Hart, Margaret Drost, and Jim Drost. So with that, Mr. Reingold, do we go back to any of the applicant or the planning department, or do we go into debate?
So at this point, the applicant had requested a 3 minutes for rebuttal, so we should give him his opportunity.
Okay, 3 minutes, Mr. Herzberg.
Mr. Chairman, members of the committee, I understand the concern. I do. And I also understand the idea that it's not what they want. But unfortunately, It's what's allowed. And to say that just because something hasn't developed in 20 years, even though it's been entitled for 20 years, that you should somehow go back and relook at it, would they apply the same type of restriction to their own property? If there was a house in those communities that hadn't been built, it was a vacant lot, would the property owner of that lot be willing to surrender his residential development? I don't think so. I think he'd say, I have certain rights. I have rights because of the land use or the zoning that's in place. That's what this property owner is saying. A lot of what you heard, allegations of too small of houses, well, self-storage isn't related solely to the size of the house. People with large houses need self-storage as well. The idea that somehow a fundamental change in the area has occurred and you should no longer recognize the allowance or the entitlements that this property have, to me, just seems to be a taking it by the very nature. As to light pollution, this property could be developed as a 12-acre shopping center with 35-foot plus poles that would run all night long. And as a commercial land developer, typically you do need to run those lights all night long because there's security issues and insurance matters that you have to protect people on those properties. This owner is not doing that. He's not putting up 35-foot tall poles. He's keeping the light on his property. It's a smaller development than would be otherwise allowed, but there are other landowners in this PUD that still have rights. Tomorrow, someone could come in with a verification of substantial compliance for a liquor store on one of these corner lots, and again, the city nor the neighbors could refuse him. It's an allowable use, as is auto repair. And there are no hours of operation in the PUD that are limited. Any of the users could operate 24 hours. So to limit this user in his hours of operation, again, seems to be a taking of otherwise the rights he has. You heard comments about how that this was an increase, a request for an increase. It isn't. It's an allowable use on all 12 acres if that's what they decided to do. Might not be the original drawing that was drawn, but the written narrative clearly says that this is a concept plan for that PUD in 2007 and that there will be changes that come as different users come and go or as different users take development. This developer has tried to leave additional square footage for the other users so that commercial outparcels can be developed. You've got a dramatic reduction in traffic. You've got no access to a roadway that otherwise he had a right to access to, which is apparently near a bus stop. I think the applicant has gone above and beyond. With that, I'd ask you to consider the criteria and remind you that you are bound to the substantial competent evidence related to that criteria only. Thank you.
All right. Thank you so much. With that, committee members, we will open it up for questions, and we'll leave the public hearing open in case anyone has any questions for Ms. Abney, Mr. Herzberg, anyone in the community. First, we have Councilmember Arias. You're recognized.
Thank you, Mr. Chair. So I wasn't going to speak much tonight, but obviously I heard the concerns from the community. So I'm going to just ask Mr. Reingold on your official statement if I'm having to recuse myself from this voting or not because of potential conflict of interest or not.
Through the chair to Councilmember Arias. So under 112.31434 to statutes, you have a conflict of interest in a scenario in which an item basically inures to your special gain or loss. So the question would be, well, does this appeal inure to your special gain or loss? That would be a conflict of interest for you. But on top of that, it would also have an issue of whether you know it inures to the special gain or loss of a principal by whom you're retained or to the parent organization of a subsidiary or of a corporate principal with whom you're retained. And so the question then is there some entity that you're employed by or you're principal of or whatever who's benefiting from this?
No, sir.
And that doesn't look like it. And then finally, whether you know this decision inures to the special gain or loss of a relative of yours or a business associate of yours. And so to that, I'm not aware of any benefit to your family and or any your business associates. So with that, I'm happy to answer any additional questions.
All right, thank you. I just wanted to make sure that the committee understood that there is no direct or indirect benefit just because a member of the applicant's family works for me has nothing to do with any of this. I'm not getting any kind of gains out of it for my family or me in general. I'm strictly going off of this based off of the facts that I have here. Mr. Chair, now I'm going to actually elaborate on some of the facts that I gathered. All right. So, Mr. Herzberg, if you don't mind, through the chair, may he come up? Thank you. All right, Mr. Herzberg. So we've obviously, I looked at the map here. We have the green and the yellow. The yellow's already been essentially approved by the current person you represent, and the green is by the other person that wants to sell to yellow. Has green sold to yellow yet?
To my knowledge, sir, he has.
Okay. Now, if green hadn't sold to yellow, all right, by the use right now that was adopted 20 years ago, green could also create storage unit. And green could have created a storage unit of their own and had access from Yellow Bluff Road as well. And yellow could have had a storage unit of its own coming from Starrett Road. So you would have had two entrances from two different storage units. So that to me is a plus that now you're going to alleviate one of the entrances and only have it to go to Starrett Road. Did I gather that correctly? The only entrance now is Starrett Road, right?
Through the chair, that's exactly correct, sir.
Thank you, sir. The other part is I did have concerns, and somebody addressed it, that they requested it. The buffer that you have, the landscape buffer, and how tall the fences are going to be and all that, I want to make sure that these are aesthetically pleasing to the neighborhood too, because I'm looking at the map, and there is a neighborhood across the street. I want to make sure that, aside from the final fence, that there's enough landscape buffer to make sure that it doesn't look like a self-storage unit. Is that something that you're going to be able to address, and if anything, implement a little more landscaping buffer as they requested?
Through the chair, sir, the development as it proceeds through the process would be required to landscape according to the city code. So because there are vehicular use areas in there would be required landscaping along that side. And I think you'll see a pond is actually located in that area of the property closest to Yellow Bluff. So there's an additional buffer being the pond there, keeping these buildings further away. And these are one-story buildings. Maximum height of these things, I think, is about 13 feet tall. So it's not something that's going to rise up. It's much shorter than the residential units across the street, sir.
Okay. And then regarding the light pollution, I definitely feel for them on that part. The gas station shuts off their lights after 10 o'clock. That's what they stated. I don't know. I'm just going off of what they said. Is there a way or some sort of device that your whoever's doing this, I don't know if it's a self-storage unit, Atlantic Self or CubeSmart, that they have some sort of automatic dimmer or lighting turn off where if no cars enter past 30 minutes, it automatically shuts off. That way, when a car does enter, it goes back on and to a smaller capacity. Is there something that there's technology for that or not?
Through the chair, sir, I can't speak to that technology specifically, but I can assure you that the developer is willing to submit to a condition that he provide a photometric plan at the time of building permit to assure that the lighting on the property would not create trespass lighting. This is standard language that the planning department uses for these type of matters, and that would assure that no lighting comes outside of the property, sir.
Okay, yeah, that's a good one there. And then regarding on-site staff, there is, so if I understand correctly, there is no staff at all there. This is more of a smart storage type of unit facility, right?
Through the chair, that's exactly correct, sir.
I have a few of those in my district, and I'll tell you right now, they're as safe as they can be. And regardless if there's people there or not, I actually go to 3 storage units as well too, and whether there's people on site or not, they still don't know what I'm taking in there. They're not asking me every time. I could go in my big van and take my boxes, whether they're manned or not. It's irrelevant at that point because nobody's actually checking me. So I don't really buy into that part of it. I definitely buy into the part of light pollution, accessibility, make sure that we limit the amount of accessibility. One entrance is ideal because I was actually going to suggest that, but obviously seeing this here. And the closest storage units to in my district, for example, Deerwood Country Club, they're 2 miles away. Deer Creek Country Club, 2 miles away. E-Town, 3 miles away. So the lady that brought this map, this is actually what I was actually looking up to make sure how close the proximity is to the nearest storage unit. And they're over 4 miles on one side, and there's one that's 3.2 miles down the other road. But there really aren't any, if anything, at all in that part. Is there a need in the community? That's not my choice. But I do know for a fact that there is property owner rights, and the property owner does have the right to build whatever they want, as long as it is in accordance with the laws that we put in place. So that's it. And I just wanted to make sure that we clear the air regarding my quote-unquote not really conflict of interest. There is no conflict of interest. Otherwise, I wouldn't be voting on this matter. Thank you.
Thank you, sir.
Councilmember Johnson, you're recognized.
I guess my question would be more for planning, but I may have some for you, Mr. Hertzberg. I'll let you know. Either planning or legal through the chair. I'm not sure which one, but and I certainly appreciate, Mr. Chair, the community for coming out and giving us those details. And I've been researching this since we got the appeal from Mr. Reingold. I'm curious, and I went copiously through 2007-382. Based on your observation, either planning or legal, is this use, while it's not prohibited by right in the PUD, is it permitted by right in the PUD?
Through the chair to the council member, yes. So it is a use that is permitted by right within the PUD.
If so, I know that there are questions being asked about things that can be done to the property, but aren't all of those questions, and I guess maybe this is probably more legal than anything, aren't those questions moot if the PUD already entitles the property owner to certain rights? Can you give me some feedback on that?
Through the chair to Councilmember Johnson. So typically the authority to interpret, enforce, and administer the zoning code lies with the plan department, and I would defer to them. However, I think you make a valid point about those uses are allowed by right.
And with that, thank you, Mr. Reingold. With that, through the chair, would we have the ability to Ms. Abney to tinker with anything that is like, because to me it looks like that would be not what we are here to do, to come in and say we can now change the PUD that was approved in 2007. Can we do that?
Through the chair to the council member. So in regards to tinkering with allowed uses, so whatever is listed there today, those are the uses that are allowed. So they could go on any of those parcels. Mainly what this minor modification is for is to update the site plan. There's the removal of driveways and cross access. So that's the main reason why the department felt that the need for the minor modification to update the site plan. If there were uses that were, like, let's say, allowed by a zoning exception, then we could go through the analysis of whether or not we find them compatible with the surrounding area. But because these uses are allowed by right, you don't get that ability to determine on whether or not they can go there.
Mr. Chair, I think Mr. Reingold wanted to jump in.
Yeah,
I have one last one, and I'll be done.
Sure. Go ahead, Mr. Reingold.
Through the chair to Councilmember Johnson, I do want to clarify, one of the criteria of a minor mod, though, is that there is no change in the approved permitted uses, comma, including the amount and general location thereof, and no movement or relocation of specific uses on or along the perimeter of the site. I just wanted to clarify that issue.
Okay. I think this will be my final question. I'm still looking at all of the details. Could someone give me your specific, and please don't read it to me because I know it's here, but if you could just give me like a layman's term, what is your definition and understanding of minor mod versus substantive mod?
Yeah, so through the chair to the council member, so the way that the planning department reviews
Or
it
substantial
is that,
change, I'm sorry.
Yeah. So we go through the criteria that's laid out on whether or not you can approve a minor mod. And if we find the request does not fall within those allowed criteria, then we would classify that as a major modification and needs a new rezoning. So example is like if the use is not listed there, that would be a significant change. So then you have to do a new rezoning. Are you asking for more square footage than what was originally permitted? The question of like, does the change in driveway access or distribution of traffic, is that significantly altered in what was originally permitted? And again, with the removal of the driveway, we had it run by our both our traffic reviewer and development services and our transportation division, and they did not find that it was a significant change in the distribution of traffic. Or if there were any conditions that are placed on by city council that they wanted to remove, all of those different changes, those would be considered a major modification, and then they would have to go through the full public hearing cycle to rezone the property.
Gotcha. Thank you, Mr. Chair.
Okay, Councilmember Gaffney, you're recognized.
Thank you, through the chair. If you don't mind, I want to bring the first gentleman up. I know he said he wasn't finished speaking. I know I got to ask you a question.
What, Mr. Reingold? Mr. Adams, yes.
Mr. Adams, I'm sorry about that. I know you had like 2 more minutes that you wanted to if you keep it brief, that you
Yeah,
want to
no,
finish. Yeah.
I just wanted to bring up, I understand that this is considered to be a minor modification that you're saying, and I know at our last hearing, one of the council members brought up the idea that, oh, well, it's nice that they're not building up tall or anything. This is going to be widespread and low to the ground. But let's be honest, if you don't approve this modification, it's unlikely that they're going to build these storage units there. They're coming in because they want to be able to build 33% larger in this location. So let's not do that. If truly this overwhelming need exists for these storage units right in the middle of all of our houses, let's make them build something nice. Let's make them build something, a nice multi-storage unit that requires air-conditioned unit with freight elevators, fire exits, and let's make something nice. This is your opportunity to make this area of town nice. We could expand our roads, make this intersection safer, and build something nice right here that's going to entice additional buildings to come and build near it. I understand your face that you're saying, oh, maybe not, but the fact of the matter is that they're not going to do it. If you don't approve this, they're not going to build a multi-storage unit because it would cost them so much more money to have to build a large multi-storage unit with air conditioning and freight units. They're not going to do that. So instead, what they want to do is they want to swallow this secondary parcel and then expand by 33% so that we have this additional huge storage unit right in the middle of where this committee has decided it should be residential area.
Okay.
And so that is what I was trying to get to. Thank you
right.
very much. I appreciate it.
Thank you. I appreciate that. One last question. I'm going to bring one other person up, Miss Ruth, Miss Nelson. If you could come up, I know you had reached out to me and you brought it to my attention through the chair about JEA. JEA, I think a substation.
Located right outside the area on Yellow Bluff, there is a JEA substation, and we have a great deal of concern about the fact that combustible materials may very well be stored in this property right outside, right close to this JEA substation that is supposed to regulate our electricity in that area.
Okay, thank you. I don't have an answer to that question. I'm not sure if Dylan or Aaron, even Mike, I want to take a stab at it. I want to make sure we address that concern that she have about this JEA substation. I don't know.
It's not something we can address, Councilmember Gaffney. We don't need.
Okay. All right.
All right. Councilman Johnson, you're recognized.
Okay, I'm now confused. I thought can you, Mr. Chair, define what our job is right now? What are we supposed to do in this moment? Because I thought we were supposed to make a decision as to, do we uphold the language that's in the PUD? That's why I asked those questions. Do we uphold the language of the PUD? Are we changing stuff? And from my understanding, we can't go in making changes. So can you tell me, what are we here now to do at this point?
Sure. Thank you. I'll take my best shot, and then Mr. Reingold, if there's anything you need to correct. So the applicant went to Planning Commission with a minor modification to the PUD. Because those do not come to LUZ, they lost at Planning Commission. They are now appealing it to us, LUZ, and Council. So our job here today is to make a determination whether we grant the appeal or deny the appeal for the minor modification that Planning Department gave approval for, Planning Commission denied. So it's strictly just, do we approve the minor modification or not? Correct, Mr. Reingold? Okay, that's it. Yeah. All right, so we have no other speakers in the queue. So we'll go ahead and close the public hearing and bring it back to committee. And now we need before we get started, we have to amend the bill because it's in a neutral position right now. So we have to come to a consensus here on, do we want to amend the bill to grant or deny the appeal? And I'm just going to go ahead and, make a few observations here. All of the concerns that I heard, I've got 6 things on here. And one was that there's too much storage units around this area, and there's going to be more traffic, therefore more accidents. There's going to be increased crime because of what's being stored or what's potentially being stored, light pollution, and this perhaps shouldn't be a minor modification, and then there was another mention of AI being the security measure versus a real-life person. So with those concerns, unfortunately, those are not something that really we can warrant as competent substantial evidence. What's being stored or what's not being stored, that is not something we can take into consideration. Too much storage being around there is not something we can take into consideration. More traffic in the area that therefore causes more accidents is pretty much this is the most minimal use of traffic that is possible for this site. And light pollution, I would just say, no matter what is going here, there's going to be lights. And with the gas station argument, the gas station is on the corner of Starrett and Yellow Bluff, and it's basically in people's backyards across the road. This development, I don't understand. I mean, unless this is a very outdated picture in all the maps that I've gotten, I don't see any like residential around. Like that would be a major concern for the light that's going to be there. We've addressed why it's not a minor, or why it is a minor modification. So I'm just struggling on like what's the middle ground, because those items are just not something we can use. Now theoretically we could use them, and the gentleman just got up and said, well, what's going to happen is if we deny this, then they won't build anything. And Mr. Adams, I would argue that that's not what would happen. What does happen on a very frequent basis is we get taken to court, and that's why these hearings are called competent substantial evidence that are quasi-judicial. And what happens is we get taken to court, and we have to justify, why did we deny it when our planning department, who are our experts giving us competent substantial evidence, approved it? And then that puts us in a very terrible position in court. So then what happens is the judge says, you're wrong, the applicant wins, and then they don't come back here and they just build whatever they want. So it's really not a good situation to go to court. We try to get it all done the right way here. Furthermore, I think both of these parcels, if I'm understanding correctly, whoever, Ms. Abney, the yellow and the green, they can build storage on this right now by right without having to ask us for anything.
To the chair, yes, correct.
So what would happen if they just said, okay, cool, we already have the entitlements, we're just going to build it on this and not connect them?
So each one will have an access point, so you'll have the additional driveway that's along Yellow Bluff.
Mm-hmm.
They still have to meet all the like buffering requirements and fencing and setbacks and all of that, but yeah, you could theoretically
But they're entitled for that right now.
Correct, yes.
So they could just build it.
Yes.
Okay. So committee, that's kind of where I'm at right now is we can't dictate something for them not to do that they're already entitled to do. Sir, you're out of order. Do not speak out loud. You'll have to get removed if we do that. So, all right. So with that, yeah, we have Councilmember Freeman. Go ahead.
Thank you, Mr. Chair, and for your explanation. And I will say that I do share some of the similar frustrations as those sitting out in the audience, as one that drives frequently through that area. I do understand competent substantial evidence. I do understand my role sitting in this seat, and this is where I have that internal conflict of late, and it's where I've been saying more and more as we get to it, like things like this, development coming this way, applicants start coming and talk to me. I did have the chance to talk to Mr. Herzberg and had a little more ease when I realized that these weren't a bunch of homes coming in that are coming up and down that road right now. But I did ask one question, and I'll put this out here through the chair to Mr. Reingold or to our planning department or to you. That intersection is a very unique one. It's diagonal. It is very difficult if you're trying to make a left turn. No matter which way you're going, cars are stuck in the middle of the intersection going around. And I asked the question, And I'll ask the question of, in which case of any type of development that will be coming in this area, could that be a condition or something that is brought up or considered when we're talking about traffic? Because that intersection is definitely it's a challenge. I don't know who engineered it, but it needs to be re-engineered. And I think that's where I would have focused a lot of my conversation and my thoughts, and I did in my meeting, was that. Now, the development is development. They have their right, but that intersection is dangerous. And so is there any way or any conversation that can be had as we move forward with these parcels here? There are 3 other parcels that are closer to the intersection. Is there anything that we can do with those 3 other parcels that can ensure that if a developer comes in to do something there, that they understand that they must address that intersection as well? Crosswalks, sidewalks, all the things that will make that area safer for people that are walking from, I'm drawing a blank on the neighborhood on one side, Eagles, or whatever it is, coming up to that Circle K, all those types of things.
I mean, I'll let Mr. Reingold answer, but I would say on this appeal, there's nothing we can do regarding that. That sounds like a CIP project for the council member. And perhaps if there was a development actually in the corner of this intersection, because I agree with you, it's wonky to say the least. But in our posture right now, I don't believe that there's any method to take to fix that. That's a major problem. And I know Councilmember Gay or Councilmember Gaffney have had, discussions about this in finance about getting streetlights and new traffic patterns and stuff like that. So I think it's a separate bill, to be perfectly honest. But if Mr. Reingold has anything to correct me on.
No, thank you, Mr. Chair. He's not going to correct you. I oftentimes will ask questions with the intent of putting things on the record, and that was really more of a rhetorical statement. And I did hear a conversation earlier today about CBA dollars and folks talking about the usage of it. I think that if we have scenarios where developers by right are able to do things and it's causing some consternation and heartburn with our residents, maybe this intersection is a compromise that we can offer that will say, hey, this will improve your quality of life, at least in this area where we heard a gentleman say 25 minutes that you sit there trying to turn left. I have 2 young drivers right now. I don't let them go that way during that time of the day. It's not safe. So that would be something that I would love for, the council members maybe to look into. And so I was just putting that on the record. Sorry.
Okay. Thank you for getting that on the record. Councilmember Gay, you're recognized.
Thank you, Mr. Chair. I'm just trying to find out where we are right now. We're still in the, we haven't closed it to bring it back to the.
Yeah, we've closed the public hearing. It's at kind of the stage right now is we're looking for a consensus before we make the amendment to grant or deny the appeal.
Okay, and then we can speak after.
Yeah, so right now is when we would like to hear your comments on whether you support it or oppose it.
All right. Well, thank you. If you don't mind, a few concerns I have, and Ms. Abney, if you would come back up, is we got green and yellow, but the original, here's where the frustration is at and where it's frustrating to the community because make it make sense because it doesn't make sense that we've got a PUD from 2007 that's got a site plan that says this is what they're going to build. But it also it's allowed, a selection of other items that could be built. But they selected this as what they're going to build. That's in say the yellow. But it's all inclusive of the green. But now, Ms. Abney, through the chair, is why wasn't the yellow considered a minor modification? Because there's no differentiation between the green and the yellow of what the original PUD was.
Through the chair to the council member. Yeah, so the yellow is in the general location that was originally contemplated on the conceptual site plan. They were keeping that. There was going to be potentially the cross access. You still had all the out parcels still available for development. What the new site plan that came to us included was expanding the development not just from the center, but it included one of the out parcels. So now you're combining out parcels. You're also removing driveway accesses that were originally contemplated, and then it also included cross access, which now is being removed. So between all of those different changes, the department found that it was substantial enough of a change to justify the need for a minor modification. And then when we reviewed that request based off of the criteria, we found that it met it in order to be able to recommend approval.
I mean, through the chair, in past circumstances where this is basically going from PUD to PUD, and it's really not a minor modification because you're actually changing the original site plan that was submitted. And so we battled that all the time about, oh, it's conventional zoning, don't need a site plan. But it's a PUD, you need a site plan. And now you're moving away from it, saying, well, that really doesn't matter. And there's got to be some validity to the original site plan that's just being discarded. And it should, like I said, the whole problem here goes back to the original yellow not even being, saying by right, you change the site plan to where they can build these other items that are over here that they didn't select to begin with in 2007, but now we select to build them in 2026 to where it just gets so convoluted. And that's what the Planning Commission seen, what was going on. And that's why it was denied. And so there's a lot I would like to say about this, but that's it in a nutshell. And to be for clarity, this where this is being built is not my district, but it's at this intersection I have three corners or three sections of it, and this is the fourth section that's Councilman Gaffney's district. But most of the majority of the people here are being affected are from my district, so that's why I'm here to support them. And I think we need to really look at what the original PUD was, and I think that's what the community is leaning more toward. That's what they want, is what the original PUD was. So thank you.
Councilmember Johnson, you're recognized.
Thank you, Mr. Chair, and thank you, Councilman Gay, for being such a great advocate, because I think this is so important that this is why we're here, so we can get these questions answered. But it leads me to other questions, and so I guess legally, we're talking about a 20-year-old PUD, so I guess this is a legal question through the chair. If the site plan has a PUD that is that needs to change, but the change of the site plan still stays within the permitted and entitled uses, does that mean that have to, obviously to me it's what it seems, I'm just going by the law. It seems minor, but can you help me out with that, Mr. Reingold? Are you locked into that? Because from what I'm hearing now, if you have that PUD and it's there and it's approved, you don't have to go by that. When I say go by it, you don't have to have it in specificity as long as it remains for the entitled uses. Can you help me with that, please?
Sure. So you would need a minor mod, but not a PUD to PUD rezoning if there is no change in the permitted uses, including the amount, and this is the phrase in the zoning code, and general location thereof, and no movement or relocation of this. So it's the general location thereof is kind of the key words that jump out at me in that statement for a minor mod.
Also, I made some notes, the daily trips and the percentage of capacity for those roadways, based on what I read here, what I heard in testimony from Ms. Abney, and what I saw earlier, it would be a decrease on capacity as well, which should still keep us in the way of being a minor modification, correct? Since the capacity of somebody, I mean, I don't know, planning or legal, but I think those two things, I really want to, my heart goes out to this community because they're saying, hey, this is something that we really don't want this use, but then I have to look at both property owners, and I kind of defer to our chair who says this is not why we're here. We gotta go by the law that has been prescribed for us, and while my heart breaks, the law doesn't speak to that. So am I correct in that with the capacity as well?
Yeah, so through the chair to the council member. So one of the criteria is driveways and or streets do not significantly alter the general distribution of traffic within the PUD. And so with that general question, we send it over to our transportation team, our traffic engineers to review it. And I know one of the key things that they look at is the type of use and the impact of traffic that it's going to be on the roadway. So when we looked at this one and what they're entitled today, the 105,000 square feet of commercial uses, and what the traffic could be generated with those uses is significantly larger than the proposed personal property storage facility. So when looking at that, there is a significant decrease in the impact. So with that reasoning, they were fine with removing that one driveway because you are not creating an abundance amount of traffic and then also going down to just one driveway, which would empty out onto Sterrett Road.
All right, so I think we've had all the speakers that needed to speak, so now we're just going to kind of get a consensus. We're going to go around the horn, and we're going to see who wants to... Okay, Councilmember Gaffney, do you want to speak?
Yeah, I want to be last, though.
Oh, yeah, yes, sir, you're last. Go ahead.
So, I'm last, then we, vote?
Well, yeah, we're going to have to take up a decision of whether we want to grant or deny, so we got to get a consensus for that. Now's the best time for you to speak.
Okay. Mr. Hersberg, if you could come up 1 second. And I don't know if this is a question for you or the planning department. Is it a cap on these storage units? I mean, I know right now he's trying to add, I think, 122.
Through the chair, so the total would be 650. I think and really the PUD goes by square footage, so square footage is probably the more appropriate use or way to look at it. I think 85,000 is where they'd be at. The PUD allows 105 plus a 10% differential, I believe, was in the language of the PUD. So, but yes, it's somewhere around 650 total units. Yes, sir.
Okay, so but is it a cap? So I guess 650 is a cap. He can't go no more than 650, right?
That's all we're showing on the site plan. So.
Through the chair to Councilmember Gaffney. So the key is we recognize the issue in terms of square footage. So there cannot be an increase in the amount of non-residential floor area. If that means 500 units, 600 units, 700 units, for us, it's whatever the square footage is in the PUD.
Okay. All right. And this is all first floor. It's not second floor, third floor, fifth floor, sixth floor, correct?
Through the chair, yes, sir, that's correct.
Okay. All right. Thank you, Have a seat.
Thank you.
So, you know, this I ain't gonna say it's a tough one. So at the end of the day, I think what we trying to figure out is we gonna approve 122 units. I think 560 have already been approved, technically. So right now, we trying to figure out if we go approve 122 units. You know, this been on my radar, I think, going on now for like 3 to 4 months. You know, I found out about this, honestly, through a Facebook page, because originally it didn't have to come before City Council. It had to go before the Planning Commission. You know, so I found out about the Facebook page, I found out about the petitions, and at that point, constituents started reaching out to me, I think prior to like Christmas or like New Year's. I even went out there, I went to Mr. Jason's house, and I don't have to, I guess, repeat the facts, what the constituents said. I think I'm going to be a no tonight. It's not that I think. Won't support this tonight. Pretty much what the constituents said. You know, these constituents been out there the last 20 to 30 years. These are the expert testimonies. I think this area has been residential, and I would like to keep it that way. I think when you talk about storage unit, I think storage units should be placed in industrial areas, and this is not an industrial area. I mean, also the infrastructure. It's a 2-lane highway. I know we spoke about the traffic. It's a 2-lane highway. I don't know if we have the appropriate infrastructure for box trucks, moving trucks to be coming in and out this area. I think we setting ourselves up for disaster. You know, I think the community said at the community meeting they would like to see something more vibrant, a shopping center, more people, just something to enhance the community. I would like to see the same thing. So as of right now, you know, and I don't take the Planning Commission vote lightly. Not that nobody else won't take it lightly, but they denied this for a reason. As a matter of fact, I was there. I spent I think like 2 to 3 hours there a month ago. So I'm a no. The community came out. They came out during a public planning commission meeting, and I'm gonna stand behind the community tonight. Thank you.
All right. We have no other speakers in the queue. So what we need to do now is put the amendment on we need a motion on the amendment to grant the appeal, which would allow the minor modification, or deny the appeal, which would deny the whole thing. So, we have a motion and a second to grant the appeal. All right. Is there any speakers? Anybody has anything else? Okay. All in favor of the amendment to grant the appeal, signify by saying aye. Aye. Any opposed? The amendment carries.
Move the bill as amended.
Motion and a second on the bill as amended. No further speakers. Open the ballot. Record your vote.
Five yeas, 1 nay.
By your action, you have granted the appeal for 2026-107. All right, committee members, we're going to go back now to page 1. Item number 1, 2026-630. Yep. All right, hold on. Let's just make sure everyone's getting out safely. All right. So we're going to go with item number 1, 2025-630. Open the public hearing. No speaker cards. We'll continue this public hearing until 4/7/26. Item number 2, 2025-724 is deferred. Item number 3, 2026-006. Open the public hearing. 1 speaker card. Samantha Series.
Samantha Series, address on file. I just wanted to make sure this was going to be deferred because you didn't say that.
It's open continue.
Oh, it's going to be continued?
It's continued until 3/17.
I know, I see it there, but,
okay.
And I just wanted to, Samantha Series, address file, I don't remember if I said that, sorry. I just wanted to clarify that Dr. Johnson did approach me to help his community. I know it was kind of talked about after I spoke last time, and, I just want to make sure that you all know that I'm just here to help. I'm not trying to cause a ruckus. So Dr. Johnson and I have been in communication. I've been in communication with the neighbors. So it's not something that he doesn't agree with. He's fine with me helping. Thank you.
Okay. Councilmember Johnson, go ahead. You're recognized.
Mr. Chair, I just want to clarify this on the record. Ms. Series, I appreciate you so much. Thank you. And we've had a couple conversations. I want the record to reflect. I did not put the speaker in, nor do I have an opinion on this whatsoever. I certainly didn't have a problem. We will be having a community meeting on Monday. We just confirmed it today, but I do not have an opinion on this, and I certainly didn't have a problem whoever they got. I just want to make sure not putting my thumb on the scale, but I do thank you for your service to this community. All right, thank you, Mr. Chair.
Okay, all right, good deal. No, with that, we have no other speakers, so we'll continue this public hearing until 3/17/26. Item number 4, 2026-007. 1 speaker card, Samantha Series. Okay, doesn't wish to speak, is in opposition, and we'll continue this public hearing until 3/17/26. Item number 5, 2026-11. Council members, please declare any ex parte communication you have at this time. I have received an email from Mr. Faulkner earlier this week, and it was regarding the site plan that we have here, and this will be filed with Legislative Services. With that, we will go ahead and open the public hearing. Will we get a staff report? I think we already got a staff report. Okay, we already got the staff report. Good to go. So let's go ahead and close the public hearing and bring it back to committee. Unless, Mr. Faulkner, did you want to speak?
No, through the chair, just standing by for any questions that you may have, specifically with the updated renderings that were sent.
Okay, great. No further questions. I do appreciate you getting this turned around for me in such a quick manner here. And with that, we'll close the public hearing and bring it back to committee. All right, we have a motion and a second on the amendment. Mr. Reingold, can you please explain the amendment?
Sure. So the amendment will be that the PUD will be subject to a revised site plan dated March 2nd, 2026. That site plan essentially will be the site plan that was in your application packet already, plus the rendering that is sitting in front of you. So those documents together will make up the site plan. Second, the PUD will be subject to a condition. I believe Mr. Hunter has already agreed to them, but if Faulkner can agree to them, but if he can just give me a thumbs up or something, that it'll be subject to access maybe from Fleetwood Road and University Boulevard as described in the PUD application for storage condominiums. Any other use shall have access subject to Development Services Division and Planning Department review and approval on a case-by-case basis.
That's confirmed. We agree.
All right. And just for additional clarification, I already asked Mr. Reingold this, but just to get it on the record, during the bill, the landscaping included in this picture is included in the site plan. So once this gets attached, it will be coloring, scale, like every little detail on this page is what it will be required to be built.
That will be the site plan for that property and how it's going to be developed.
Okay, cool. And that's y'all's understanding as well.
That is our understanding.
Okay, great. Thank you so much. With that, did we already move the amendment? Okay, all in favor of the amendment with the condition, signify by saying aye. Aye. Any opposed? The amendment carries. All right, motion and a second on the bill as amended. No one in the queue. Open the ballot, record your vote.
Six yeas, 0 nays.
By your action, you've approved 2026-11 as amended. Thank you, Mr. Faulkner. We appreciate you. All right, number 6, 2026-15. Open the public hearing. No speaker cards. We'll continue this public hearing until 3/17/26. Item number 7, 2026-22. Open the public hearing. No speaker cards. We'll continue this public hearing until 3/17/26. Item number 8, 2026-23. Open the public hearing. No speaker cards. We'll continue this public hearing until 3/17/26. Item number 9, 2026-58. Open the public hearing. Get a staff report.
Thank you. Ordinance 2026-058 is for a small-scale land use amendment to change 0.49 of an acre from community general commercial to light industrial in the urban area. This application has been submitted with a companion rezoning requesting industrial light. The site is located on the north side of Balmoral Circle North, which is a local road. This is just south of Bush Drive, which is an FDOT minor arterial, and it's about a half mile east of I-95. The I-95 interchange at Bush Drive, which is west of the site, is a significant node around which commercial and industrial uses are located. The subject property is in an area identified on the industrial preservation map within the comp plan, and it's identified as an industrial situational compatibility zone. Industrial situational compatibility zones are areas that are strategically located to provide access to rail facilities or trucking routes, serve ports, or serve airport multimodal requirements. These areas are presumed to be appropriate for land use map amendments to industrial categories. For these reasons and those in the staff report, the department recommends approval. The Planning Commission heard the item at their February 19th meeting, and they unanimously forward a recommendation of approval. Thank you.
All right. Do we have any speaker cards on this one? No? Is the applicant here? No. Go ahead, Councilmember Gaffney.
Yeah, thank you through the chair. So I met with the applicant. The applicant doesn't speak English. So I met with him like a month ago. We met in my office with Yaya. She was the translator at the time. So prevent him from.
Got it. All good.
Yeah. So. Yeah.
All right. All right. Although we do have a bilingual committee member here who has done this before in the past. But anyways, yeah. But it's all good. Okay. With that, we'll close the public hearing and bring it back to committee. Motion and second on the bill. No one in the queue. Open the ballot. Record your vote.
6 yeas, 0 nays.
By your action, you've approved 2026-58. Item number 10, 2026-59. Council members, please declare any ex parte communication you have at this time. Councilmember Gaffney.
Thank you. Through the chair, I'll be quick. I don't want to arise to declare ex parte. I met with the applicant in my office, I think a month ago. Through his translator, he asked me, did I have any questions? I asked him, I asked her questions to ask him, but I didn't have any questions, so I made sure everything got filed with legislative services.
All right. Let's go ahead and open the public hearing and get a staff report. Oh, did you have ex parte, Mr. Arias?
No, Mr. Chair. I was actually going to say I do not declare ex parte because I was not the translator at the time, so I have nothing to declare.
Okay, all right, yeah.
Thank you. This is the companion conventional rezoning ordinance 2026-0059, seeking to rezone the same 0.49 acres from CCG1 to IL to allow for outside storage of trucks and trailers. The subject property is located just south of Bush Drive and east of I-95. Staff reviewed the request and finds that the proposed use is consistent with the comp plan with the land use category of light industrial, which would allow for the outside storage. We do note it's located within the industrial situational compatibility overlay, which are areas presumed to be appropriate for land use amendments to industrial categories due to their location to rail facilities and truck routes. The surrounding area is a mix of commercial, business park. There's light industrial and heavy industrial zoning within the area. There's properties to the south that are zoned IBP, which would allow for the outside storage by a zoning exception. And then to the north of Bush Drive, you also have heavy industrial zoning districts that would allow for the outside storage as well. Given the existing development pattern and surrounding zoning districts, we find that the proposed rezoning is consistent and compatible, so we forward a recommendation of approval. It was heard by Planning Commission on February 19th. There were no speakers in opposition and little discussion amongst the commissioners. The commissioners did find that the industrial zoning would be appropriate given the existing industrial developments in the immediate area, and they had no concerns on the proposed rezoning, and they voted unanimously for approval.
Okay, thank you so much. We have no speaker cards, so we'll close public hearing and bring it back to committee. Motion and second on the bill. No one in the queue. Open the ballot. Record your vote.
Six yeas, 0 nays.
By your action, you've approved 2026-59. Item number 11, 2026-60. Open the public hearing. No speaker cards. We'll continue this public hearing until 3/17/26. Item number 12, 2026-83 is deferred with the public hearing next cycle on 3/17. And then the following bills are also deferred. 2026-84, 85, 86, and 87 are all deferred. Item number 17, 2026-88. Council members, please declare any ex parte communication you have at this time. Councilmember Johnson, you're recognized.
Thank you, Mr. Chair. I rise to declare ex parte. The applicant has several properties in my district. We spoke last week about this property, and I actually got information from him that has been filed with the Legislative Services. Thank you.
All right. Councilmember Gaffney, you're recognized.
Thank you, through the chair. I also rise to declare ex parte. I met with the applicant after city council meeting last week. I know he came up and spoke, so I just asked him some questions about the project. I made sure everything get filed with Legislative Services.
Okay. We have no other ex parte, so let's open the public hearing and get a staff report.
Thank you. 2026-88 is a waiver of road frontage that seeks to reduce the required minimum road frontage from 48 feet to 40 feet to allow for the development of a single-family dwelling. The subject property is a 0.10 acre lot located along Dillon Street, which is a public right-of-way. The property is zoned RLD 60, which requires 48 feet of frontage. However, the subject property is only 40 feet wide. According to historic records, the subject property was originally platted as a 50-foot wide lot. However, at some point, the western 10 feet of the lot was conveyed to the neighboring property at 3252 Dillon Street. Due to this, the applicant needs the waiver of road frontage and the companion administrative deviation that will be heard next in order to develop the lot with a single-family dwelling. Staff finds that there are practical difficulties with meeting the strict letter of the code due to the portion of the site being conveyed to the neighboring property and it being impractical to obtain it back due to the neighboring lot being developed. Staff finds the request consistent with the comprehensive plan and compatible with the surrounding area of single-family dwellings and forwards a recommendation of approval.
All right, we have one speaker card, Mr. Travis Moss. Come on down. Your questions only? Okay, yes, sir. No one's in the queue for questions, so let's close the public hearing and bring it back to committee. All right, we have a motion and a second on the bill. No speakers in the queue. Open the ballot, record your vote.
Six yeas, 0 nays.
By your action approved, 2026-88. Item number 18, 2026-89. Council members, please declare any ex parte communication you have at this time. Anybody? Or was it on the first one, or just the... Okay. He's got one more. Okay. Just say same. Councilmember Johnson.
Rise to declare, same, filed
Okay.
with Legislative Services.
Councilmember Gaffney. Same as the first one.
Rise to declare same from last bill.
Okay, got it. Let's open the public hearing and get a staff report.
2026-89 seeks an administrative deviation to reduce the minimum required lot area from 6,000 square feet to 4,205 square feet and reduce the required lot width from 60 feet to 40 feet. As previously stated, the property is owned RLD 60, which requires 60 feet lot width and 6,000 square feet of area. This area was historically platted as 50-foot wide lots with 5,000 square feet of area, including this lot. According to historic records, the western 10 feet of the subject site was conveyed to the neighbor at 3252 Dillon Street, which now makes the subject site nonconforming with the zoning district. Staff finds that while the lot is smaller than what it was historically platted, it is still compatible with the surrounding area and permits development of an otherwise undevelopable lot. For these reasons and those in the staff report, we forward a recommendation of approval.
All right, thank you so much. We have one speaker card, Mr. Travis Moss, in support. Questions only. Great. All right. No other speakers. Let's close the public hearing and bring it back to committee. Motion and second on the bill. No one in the queue. Open the ballot. Record your vote.
Six yeas, 0 nays.
By your action, you've approved 2026-0089. All right. Item number 19, 2026-91. Let's open the public hearing and get a staff report.
So ordinance 2026-091 is for proposed modifications to update the 5-year capital improvement schedule of projects within the capital improvements element of the 2045 comp plan. This is required to be updated annually by Florida statutes. Basically, this is just a planning document. It's a compilation of what has been approved already from the last CIP ordinance, which was 2025-505. This just ensures that we have the infrastructure to keep up with growth. It is not a budget document. It's just a planning document. Thank you.
Got it. All right. Yeah, I noticed that right after I said that. Okay, so we have one speaker card, John Nooney. Looks like he's not here, so we'll go ahead and close the public hearing and bring it back to committee. Move the amendment. All in favor of the amendment signify by saying aye. Any opposed? The amendment carries. Motion and second on the bill as amended. No one in the queue. Open the ballot. Record your vote.
Six yeas, 0 nays.
By your action, you've approved 2026-0091 as amended. We already took up item 20, 2026-107. And then the following bills are on second reading. 2026-122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134, and 135, and 137. With that, committee members, this meeting is adjourned.